Hello everyone, welcome back to Labor Standards and Social Legislation. So for this video, we will discuss about the basis for the enactment of labor laws. So there are three bases for the enactment of labor laws, which are as follows. Number one is police power, second one is social justice, and the third one is Doctrine of Incorporation. So let's start discussing police power. So what is police power? It is the power vested in the legislature by the Constitution to make, ordain, establish all manner of wholesome and reasonable laws for the good and welfare of the state and its people. So the basic purposes of police power are to promote the general welfare, comfort, and convenience of the people, and to promote and preserve public health. So let me give you an example of the application of police power. We know that under Article 3 of the 1987 Constitution, we have certain rights under that particular article in the Constitution. So police power comes in if the state wanted to regulate some rights. So say for example, the provisions provided for under Section 6 of Article 3 of the 1987 Constitution, which provides that the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. So as you can see, I have put on bold the phrase as may be provided by law because although we have certain rights under Article 3 of the 1987 Constitution, or we call it Bill of Rights, the state can still regulate this right through a law. Kaya may nakalagay na as may be provided by law. So, balikan natin yung explanation. Di ba sabi ko na under the Constitution, may tinatawag tayong Bill of Rights. And under this Bill of Rights, nakalista dyan yung lahat ng mga rights ng people which should not be violated or which should not be transgressed by the government or by the state. So isa sa mga example niyan is yung liberty natin of abode and of changing the same. Meaning, we have the right to transfer our residence from one place to another and no one can prevent that or prevent us from doing so. And we also have the right to travel. So pwede tayong lumabas ng Pilipinas, mamasyal, etc. And no one can prohibit us from doing so. However, if there are certain circumstances, for example, there is a danger to the public health, just like what is happening right now in our country or even in the world, that we are now experiencing a health crisis. So if you can relate this to your daily life now, the new normal, di ba, our travel has been restricted or regulated. Di ba kailangan mong mag-present ng QR code before you can pass through one region to another or one province to another or one city to another. And yung time natin to travel is limited from 8 a.m. to, let us say, 9 p.m. kasi meron tayong curfew. So these are the things that are done in the exercise of police power by the state because there is a current health crisis or there is a current public health emergency. And so even if you have the right to travel anytime you want or anywhere you want, that can still be regulated by the state if it is in the interest of, number one, national security, second one is for public safety, and the third one is for public health. And the regulation of these rights should be done by passing a law. Kaya may sinasabi natin dito na as may be provided by law. Another example is under Section 7 of the 1987 Constitution, Article 3. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizens subject to such limitations as may be provided by law. Ayan, meron na namang as may be provided by law. So this is an example of how the state exercises its police power. And to give you further information about this police power actually is an inherent right of the state. Meaning to say, upon the existence of the state, there also exists police power. So, lahat ng mga states, gaya ng Pilipinas, meron talagang inherent power na tinatawag na police power. So, kahit na ikaw as a citizen of this country, you have certain rights under the law or certain rights that are protected by the Constitution, but still, if it is in the interest of national security, public safety, or public health, that can be regulated or restricted. So in that way, para maprotektahan yung public health, public safety, and public security, ang state is nagpapasa sila ng batas para i-regulate ang mga rights na ito. So that is police power. Now, let us take up this case of Philippine Association of Service Exporters Incorporated versus Drilon, 163 SCRA 386. Okay, the subject matter of this case is the Department Order Number 1, which imposes a temporary suspension, deployment ban on Filipino domestic helpers because of the abuses committed by their employers abroad. So merong temporary suspension deployment ban. So hindi makakalabas ngayon ang mga Filipino domestic helpers. So this is now put into issue. The validity or the constitutionality of this Department Order Number 1. Kasi 'di ba, if you can recall our discussion in Section 6, Article 3 of the 1987 Constitution that 'di ba we have the right to travel. So it should not be impaired generally under the Constitution. But if there is a valid reason, example, public safety or public health or national security, then that can be restricted or regulated. So ang nangyari dito sa case na ito, itong Department Order Number 1, sabi dito is binabawalan niya yung mga Filipino domestic helpers na pumunta ng ibang bansa para magtrabaho kasi ang reason ng department order na ito is because there are cases of abuses committed by their employers abroad. Yan yung naging reason nila. Ngayon, this case was sought to be annulled, no? For allegedly because of its unconstitutionality, for it violates the non-impairment clause in the Constitution, di ba? Kasi nga, itong non-impairment clause ng Constitution, ibig sabihin nito, if you have a contract, so if there is a law, a new law, kunyari meron kayong kontrata for employment contract, and then here comes after ng pag-enter mo into employment contract, here comes a law which prohibits that contract. So generally, that law will be rendered unconstitutional because it violates the non-impairment clause, no, in the Constitution. However, in this case, hindi mag-a-apply yung general rule kasi yung basis ng state para i-impose yung temporary suspension and deployment ng mga Filipino domestic helpers abroad is because there are abuses that were committed by their employers abroad. So the state is merely protecting its Filipino domestic helpers, and therefore, on that basis, pwedeng i-restrict or pwedeng i-regulate yung contracts or employment contracts entered into by Filipino domestic helpers abroad. So the Supreme Court upheld the said department order and ruled the consequence of the deployment ban has on the right to travel does not impair the right. The right to travel is subject, among other things, to the requirements of public safety as may be provided by law. So, since there is a danger na pwedeng ma-abuse yung Filipino domestic helper kapag inallow natin or inallow ng state na lumabas sila ng bansa at doon mag-work, then there is a that danger will be a valid reason for the state to restrict or to ban the travel. So ngayon, na-limit yung right to travel. DO number 1 is a valid implementation of the labor code, in particular, its basic policy to afford protection to labor, pursuant to the respondent Department of Labor's rule-making authority vested in it by the labor code. So, to explain it further, di ba generally, sabi natin, meron tayong right to travel no, under the Constitution. So, walang pwedeng mag-prohibit sa atin mag-travel tayo from one place to another. But if there exists a danger of to public health, public safety, and to public security or national security, then the state may prohibit you to travel. Kaya na nangyayari ngayon sa Pilipinas, di ba? If you can, ayun, balikan na naman natin, di ba? We are currently under public health emergency. Kaya on that basis, the state can actually regulate people from entering one place to another, from traveling. Kaya nga bawal sa atin ngayon mag-travel kasi nga merong public health emergency. Pero kung wala namang public health emergency, walang danger to public safety, walang danger to the national interest, then walang reason para magpasa ng batas para i-prohibit yung travel. Okay? Section 3, Article 13 of the Constitution provides that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. So let's go to the next basis for the enactment of labor laws, which is social justice. So ano naman itong social justice? Actually, social justice is not defined under the Constitution, but there are several provisions under the Constitution which speaks or which provides for social justice. So particularly under Section 1 and Section 2 of Article 13 of the 1987 Constitution. So it provides that the Congress shall give highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequalities by equitably diffusing wealth and political power for the common good. To this end, the state shall regulate the acquisition, ownership, use, and disposition of property and its increments. So actually, the scope of social justice is to, number 1, to protect and enhance human dignity. Second one is to reduce social inequality, economic inequality, political inequality, cultural inequality, property and its increments should be regulated. So, ang purpose talaga ng social justice is to diffuse wealth and political power for the common good, meaning yung social, economic, political, cultural aspects of society or should be equally distributed for the to the general public. So parang social justice means that yung wealth dapat hindi siya nakafocus in one person or in one group of people. Dapat distributed siya sa lahat ng mga tao. That is social justice. Section 2, the promotion of social justice shall include the commitment to create economic opportunities based on freedom of initiative and self-reliance. So we also have provisions or application of social justice with respect to employment. So that is provided for under Section 18, Article 2 of the 1987 Constitution. The state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. And Section 3, Article 13 of the 1987 Constitution, the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. So, kasi if we afford full protection to labor, then we can attain social justice. So these are actually means or methods for the state in order to attain social justice. Ayan. The Constitution also guarantees the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. Itong security of tenure, humane conditions of work and a living wage, and participation in policy and decision-making processes affecting their rights and benefits as may be provided by law. And we also have this principle of shared responsibility between workers and employers, and voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance with to foster industrial peace. Also, the state regulates the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production and the right of enterprises to reasonable returns on investments and to expansion and growth. So, on the basis of these constitutional provisions, kaya na-create yung Labor Code of the Philippines and other social legislations para i-protect yung mga workers. And of course, it also protects the rights of the employers. So to discuss further about the social justice, actually, social justice was defined in the case of Kalalang versus Williams. GR number 47800, December 2, 1914. So who are the parties in this case? The parties are Maximo Kalalang, and the respondents here are the public officers of the government. So there are 1, 2, 3, 4, 5 of them who are respondents in this case. So A.D. Williams as chairman of the National Traffic Commission, Vicente Fragante as director of public works, Sergio Bayan as acting secretary of public works and communications, Eulogio Rodriguez as mayor of the city of Manila, and Juan Dominguez as acting chief of police of Manila. So what happened in this case? Actually, this is a case for petition for a writ of prohibition. So when you say prohibition, meaning to say meron kang gustong ipastop, may order or rule ka na ayaw mong ipa-implement. Yan yung writ of prohibition. Now, ano yung gustong i-prohibit ni Maximo Kalalang in this case? So actually, ang nangyari dito is that merong rule na inisyo itong or in-implement itong mayor of the city of Manila, itong mga respondents na in this case actually, implementing Commonwealth Act number 548. So ano ba ang nakalpaloob dito sa rule na ito? This rule prohibits all animal-drawn vehicles to pass along Rosario Street extending from Plaza Calderon de la Barca to Dasmariñas Street from 7:30 a.m. to 12 p.m. and from 1:30 p.m. to 5:30 p.m. and along Rizal Avenue extending from the railroad crossing at Antipolo Street to Echagüe Street from 7 a.m. to 11 p.m. from a period of 1 year from the date of the opening of the Colgante Bridge to traffic. So in short, ang nangyari dito is itong rule, pinagbabawal niya yung mga animal-drawn vehicles na mag-pass along the national highway. So ngayon, ito si Maximo Kalalang is operating an animal-drawn vehicle because he is engaged into, he is a common carrier. Meaning to say, he hires, ano ba tawag dyan? parang jeep ba na public utility vehicle ba na nagpapasakay ng mga passengers and then nagbabayad sila, etc. Actually, ito yung business ni Maximo Calalang. Kaya nagreklamo siya. So ano yung mga issues na na-raise dito? Okay? Actually, may dalawang issue. Hindi lang tungkol sa police power, tungkol din ito sa social justice. Number one is whether or not the Commonwealth Act number 548 constitutes an unlawful interference with legitimate business or trade and abridge the right to personal liberty and freedom of locomotion. Ayan. Ito dong pag-prohibit ng mga animal-drawn vehicles sa national highway is nag-interfere daw ito sa legitimate business or trade ni Maximo Calalang at saka ng mga katulad niya na nag-ooperate ng mga animal-drawn vehicle. And violation daw yon ng right to personal liberty and freedom of locomotion. Ayan. Second issue that was raised here is whether or not the Commonwealth Act number 548 and its rules infringe upon the constitutional precept regarding the promotion of social justice to ensure the well-being and economic security of all the people. Ayan, ni-raise niya yung social justice. Hindi daw siya nakaka-promote ng social justice, sabi ni Maximo Calalang. Ngayon, i-discuss natin kung ano yung ruling ng Supreme Court in this case. Ayan. On the first issue, yung issue ng police power, ito yung ruling ng Supreme Court. Commonwealth Act number 548 was passed by the National Assembly in the exercise of the paramount police power of the state. Ayan. Said act, by virtue of which the rules and regulations complained of were promulgated, aims to promote safe transit and upon and avoid obstructions on national roads in the interest and convenience of the public. So, ang ibig sabihin lang yan, nung ginawa itong rule na i-prohibit yung mga animal-drawn vehicles sa national highway, ang purpose niyan is to promote safe transit. Kasi kapag the government will allow animal-drawn vehicles, alam niyo naman 'di ba, yung national highway, ang ano ba yan? Parang paspas ba ng ang traffic. So if may animal-drawn vehicle dyan na nagtatraverse ng national highway, then it could affect the flow of traffic. And it could cause obstructions to the national roads. So still, yung reason kung bakit promulgate itong rule na ito is para maprotektahan yung public. So di ba sabi natin kanina, although meron kang karapatan under the Constitution, pero hindi naman absolute yung right na yan. Kasi the state can actually interfere or can actually regulate that right if it is in the interest of public safety. So yan ang ibig sabihin ng police power. So while you have the right under the Constitution, hindi ibig sabihin na pwede mo niya exercise absolutely. Subject ka to that is subject of course to the fact na wala kang naagrabyado na tao or wala kang na-affect na other persons sa pag-exercise mo ng right. Kaya para hindi ka sumobra sa pag-exercise mo ng right, then the state will come in and through passing laws in order to regulate your actions. Ayan. In enacting said law, therefore, the National Assembly was prompted by considerations of public convenience and welfare. It was inspired by desire to relieve congestion of traffic, which is, to say the least, a menace to public safety. Public welfare then lies at the bottom of the enactment of said law, and the state, in order to promote the general welfare, may interfere with personal liberty, with property, and with business and occupations. Persons and property may be subjected to all kinds of restraints and burdens in order to secure the general comfort, health, and prosperity of the state. To this fundamental aim of our government, the rights of the individual are subordinated. Liberty is a blessing without which life is a misery. But liberty should not be made to prevail over authority because then society will fall into anarchy. Neither should authority be made to prevail over liberty, because then the individual will fall into slavery. The citizen should achieve the required balance of liberty and authority in his mind through education and personal discipline, so that there may be established the resultant equilibrium, which means peace and order and happiness for all. The moment greater authority is conferred upon the government, logically, so much is withdrawn from the residuum of liberty which resides in the people. The paradox lies in the fact that the apparent curtailment of liberty is precisely the very means of ensuring its preservation. So in short, ang ibig sabihin lang nito, there should be a balance between liberty and authority. So hindi rin pwede na yung authority ng government is sobra-sobra din. Hindi din pwede yon. Na kahit na hindi ka naman naka-affect no, to public safety or public health, wala namang issue on public safety or public health, tapos itong government is mag-interfere talaga siya sa right mo. So that would be excessive exercise of authority. Hindi din pwede na sobra din yung exercise ng rights mo or liberty. Kasi it will result into anarchy. Okay, so sabi ng Supreme Court, there should be a balance between your right and the government's authority to regulate that right in order to achieve peace and order and happiness for all. Otherwise, it would cause chaos, no? Magkakagulo tayo kung walang authority, edi yung mga tao magulo kasi walang magre-regulate sa kanila. Kung puro naman authority, magkakaroon naman ng abuse of power, di ba? Slavery ang magiging resulta. Kasi the people will now be dependent no upon the authority of the government, and they will forget their rights kasi kapag sobra yung authority na in-exercise ng government, there could be violations of rights. So that is the ruling of the Supreme Court with respect to the first issue on police power. The scope of police power keeps expanding as civilization advances. Ay, ito. Kasi di ba before, inaalaw pa yung mga animal drawn vehicles sa mga national highways. Pero ngayon, pinagbabawal na siya. So sabi ng Supreme Court na kahit na inalaw yan before at ngayon binago, hindi pa rin na-violate yung right mo to legitimate business or trade or to your freedom of locomotion. Kasi etong police power daw keeps expanding as civilization advances. So habang nag-a-advance yung ating civilization, police power also, parang parang hinahabol din niya yung advancement ng ating technology, etc. So, hindi pwedeng manatili siya sa kung ano siya noon. So, dapat mag-innovate din yung police power ng state, no? Exercise ng police power ng state. As was said in the case of Dobbins versus Los Angeles, 195 U.S. 223 to 3849L, edition 169, the right to exercise the police power is a continuing one, and a business lawful today may in the future, because of the changed situation, the growth of population or other causes, become a menace to the public health and welfare and be required to yield to the public good. And in People versus Pomar, 46 Phil 440, it was observed that advancing civilization is bringing within the police power of the state today things which are not thought of as being within such power yesterday. The development of civilization, the rapidly increasing population, the growth of public opinion with an increasing desire on the part of the masses and of the government to look after and care for the interests of the individuals of the state have brought within the police power many questions for regulation which formerly were not so considered. Now let's discuss the ruling of the Supreme Court on the second issue, which is social justice. Okay, the promotion of social justice, however, is to be achieved not through a mistaken sympathy towards any given group. Social justice is neither communism, nor despotism, nor atomism, nor anarchy. but the humanization of laws and the equalization of social and economic forces by the state so that justice in its rational, objectively secular conception may at least be approximated. Social justice means the promotion of the welfare of all the people, the adoption by the government of measures calculated to ensure economic stability of all the component elements of society through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community constitutionally through the adoption of measures legally justifiable or extra-constitutionally through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi est suprema lex. So this is a definition given in this case of Kalalang versus Williams. So, when you say social justice, it means the promotion of the welfare of all the people. Social justice, therefore, must be founded on the recognition of the necessity of interdependence among diverse units of society and of the protection that should be equally and evenly extended to all groups as combined force in our social and economic life, consistent with the fundamental and paramount objective of the state of promoting the health, comfort, and quiet of all persons and of bringing about the greatest good to the greatest number. So that is social justice. So let's proceed to the third basis for the enactment of labor laws, which is the Doctrine of Incorporation. So the Doctrine of Incorporation is found under Section 2, Article 2 of the 1987 Constitution, which provides that the Philippines renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. So actually, this particular principle finds its relevance in case where no law is applicable in a particular labor case. So say for example, if the Philippines had entered into a treaty with another country affecting labor. So provisions of that treaty or anything that has been agreed upon by the Philippines and that another country should be uh, complied with now by principle of pacta sunt servanda. So observance of treaty stipulations under the principle of pacta sunt servanda is an accepted principle of international law. The court may take cognizance of a treaty in deciding a labor dispute in the absence of an applicable law. Okay, that ends our discussion on the basis for the enactment of labor laws. See you next video. Goodbye.